Okay. Hello, everyone. My name is Howard Kline. And this is the Think Resolutions podcast. And today we're going to be talking about California Senate Bill 940. It is or was effective as of January 1st, 2025. It was sponsored by California Senator Tom Umberg. That's a state senator. It affects alternative dispute resolution services, including arbitrations, mediations, and conciliations. It relates to arbitration of consumer contracts. It strongly emphasizes disclosures of potential conflicts by proposed arbitrators. It directs the California Bar to create an ADR certification program and allows for broader discovery, depositions, and third-party depositions. I would like to do a brief introduction of my two guests. The one with the most hair in here is Jeff Kitchaven. Did I pronounce that right, Jeff?
So far, so good, Howard. Thank you.
Okay, give me enough time. I'll mess things up. Jeff is one of the country's leading mediators. He's ranked in Chambers Band 1.
Chambers is the leading international ranking service for lawyers and legal professionals worldwide.
Wow. Okay. Well, that just shows me how much of experience I have. A USA nationwide list of mediators, formerly Cruise Legal, has honored him as a global elite thought leader in mediation. He has been a full-time mediator for 29 years. Oh, you're a youngster. And his views on mediation have been cited in the New York Times and Wall Street Journal. He is an honors graduate of Harvard Law School and Phi Beta Kappa graduate of the University of California, Berkeley. And I'd like to add, he is everybody's favorite in terms of going to conferences, etc. If you follow him on LinkedIn, his shoes must be worn out. Now, Jeff, thank you for joining me.
You're welcome.
And my other guest, what?
It's a pleasure to be here. Thank you. Thank you.
You bet. And the other person with the least amount of hair here is John Derrick, who is a mediator and arbitrator with the Alternative Resolution Centers and the American Arbitration Association. Before focusing full-time on ADR, John had an appellate law practice for almost 20 years. He is a former chair of the State Bar's Committee on Appellate Courts and former editor-in-chief of California Litigation. He is a graduate of the University of Oxford and UK and UC Berkeley Law in the United States. As I said, my name is Howard Kline. I've been a California licensed attorney since 1976. And for those who can't count, that's now 49 years. And I'm feeling every minute of it at the time. All right, gentlemen. And by the way, I'm a mediator and arbitrator, if I haven't already said that. And I've been a full-time mediator and arbitrator since 2021. Recently, I spent most of my time beating up other people while you two have been spending time making everybody feel good. So the first question I should ask I think I'm going to ask of John, and Jeff, feel free to butt in on this. Does SB940 only apply to consumer contracts? And the reason why I started with this is that the first time I read the legislative comments, I had the impression that it only applied to consumer contracts. So I'm asking you the question, John, does it?
The simple answer to that is no. But assume you want more than a one-word answer. So let me explain a bit. There are really two main parts to SB 940. One deals primarily with arbitrations, and in particular with the types of solicitations arbitrators are allowed to make while handling consumer cases. And it adds, I think, even more to California's disclosure laws, which were already the toughest in the nation when it comes to arbitration. And there, on that kind of arbitration side of the new law, there is definitely focused on consumer cases. But the part of SB940 that has become most controversial, and the part that I'm most familiar with myself in terms of what I've written about and spoken about previously, is the part that deals with certifying neutrals, be they mediators or arbitrators. And with that part of the case, it's completely non-consumer neutral. In other words, the certification is in no way impacted by whether you do consumer cases or other types.
Jeff, do you know if the consumer contracts, how are consumer contracts affected by SB 940? Or would you prefer that I go ahead and kind of put that in?
Why don't you go ahead? In terms of the arbitration end of things, it's really not my bailiwick. I'm strictly a mediator.
I think in terms of a consumer contract, and if I can put this into a nutshell, basically what the law tries to do, and I think it'll be very successful, it basically says a consumer contract, a seller, or even a bank, for instance, and I'd like to use Bank of America as an example, not that it is bad, but if a bank has an arbitration provision, or I'd come up with some other vendor that sells something, Amazon as a perfect example. If they had a provision in their contract that says, if you want to buy this good, if you want to do business with us, you must agree to arbitration, and the site of the arbitration will be in Illinois, although the customer is in California, or the site of the arbitration will be in Massachusetts, and the customer is in California. The law says basically if the customer is in California, you cannot make it a requirement that the arbitration be in Massachusetts or some other state, and that the law of the other state applies. What the law requires is that California law will apply, and the arbitration, the situs of the arbitration, will be in California. And what it does is if the arbitration agreement provides for another state, it becomes voidable on the part of the consumer. And that's one of the important parts. And the substantive law remains California. Here's another thing. A court can award the consumer reasonable attorney's fees to enforce the particular section. And that might even be in an instance where the arbitration provision provides for reasonable arbitration provisions on both sides. But as I read the provision, it specifically says if the consumer has to enforce the consumer's right to have the arbitration in California and to use California law, they would be entitled to have reasonable attorney's fees. I'm assuming that even if they were to lose the arbitration. And I think it seeks to avoid a perceived lack of or loss of neutrality by the arbitrator by prohibiting solicitation by the arbitrator for employment or providing services to parties or their attorneys. It also requires disclosure of past relationships by parties or their attorneys. And we'll be talking about this disclosure because the disclosure requirements are fairly substantial. Although we'll get into it, and then I will mention that, my solution is just disclose everything. and if you don't want me as your arbitrator because I disclosed something, so be it. So how does now I'm asking Jeff this. How does SB 940 affect disclosures by arbitrators? But Jeff is a mediator. So Jeff is probably the wrong person that I should be asking this. John, maybe you can answer that.
Well, you made the answer better than I can, because like I said, my main focus as a commentator on SB 940 is on the certification side. In terms of disclosures, Howard, I'm kind of very much in your camp on this. My view is disclose everything. And frankly, California law already requires huge disclosure. So I'm not quite sure how much more there is to disclose rather than what one discloses already. If one's got any connection with anyone or anything in the arbitration, one has to disclose it, and if in doubt, disclose. The rules about solicitation, some of those are new, but again, they're sort of common sense, because there are a lot of repeat players in the consumer market in terms of the respondents, the companies, be they banks or car manufacturers or Bitcoin companies or whomever. You can't kind of be handling kind of a bunch of those cases, but then getting on the phone to them, will you make me your preferred arbitrator and others? And that's just common sense. And that whole side of the statute, by the way, is pretty uncontroversial. The main controversies surrounding SB 940, and it is a controversial piece of legislation, is to do with the certification side, which I'm sure we'll be getting onto in a bit.
Why don't we talk about the certification side?
Sure.
John?
Well, sure. What SB 940 does is to require the State Bar of California to set up a program to certify mediators and arbitrators going forward. Now, certification is not and will not be a license. You will not need to be certified in order to arbitrate cases or mediate them. What the law does aim to do is to certify people based on a, if you like, commitment to certain ethical standards. Now, the emphasis is on commitment. There's no, and well, let me back up a second. The law is unashamedly half-baked, which is a good thing and a bad thing. It's a bad thing because any law that hasn't been fully thought through is probably not the perfect statute. But so that's why it's a bad thing. However, it's a good thing because the legislature, kind of, unlike in some cases where it sends half-baked legislation kind of into the real world, in this case, the legislature recognized that it was half-baked in as much as it delegated to the state bar the task of filling in much of the detail as to how this whole thing is going to work. But it nonetheless provided guidelines within which those details have to be worked out. And the key guideline is that in order to be certified, neutral will have to, they won't have to show any level of competence. They won't have to show any level of experience. You could become certified indeed, it would appear, without having ever conducted a single mediation or a single arbitration. Somebody straight out of high school could sign up and become certified by the state bar as a neutral. What it will require, though, is a commitment to certain ethical standards. And the standards are those set forth in the rules of court, applying to mediators. And there's a parallel bit about arbitrators, but let's just talk about, from the point of view about mediators right now. Mediators who take part in court-supervised or court-arranged mediation. Many courts, be it at the trial or appellate level, have their own in-house mediation program, and you have panels of lawyers. I'm on a number of those panels myself, and the court, refers out the cases to those panel mediators, and then you have to kind of commit to those rules of court while serving as a panel mediator. What the new law says is that if you want to be certified to be doing purely private mediation, not court certified ones, you have to, as it were, subscribe to a kind of equivalent set of ethical standards. And that might sound like a good thing, and I can't say it's a bad thing, but it does bring up a bunch of potential problems.
And what would those potential problems be?
Well, the one of them is the risk that consumers, and we can talk in a minute about as to who consumers actually are, but the risk that consumers who don't spend their leisure hours reading SB940 or indeed tuning into this podcast, although they should if they don't, but that consumers will read into certification more than is actually there, and will assume that if somebody is somehow certified by the state bar as a mediator, and that they have met some standard of competence and or experience, which is actually not there in the certification process as set out by SB940. The problem becomes even more when it comes to certifying non-lawyers, because you don't have to be a lawyer in order to be a mediator or an arbitrator. And there are indeed some excellent non-lawyers who practice in both those areas. Now, the state bar, under the new law, will be able to certify non-lawyer mediators as well as lawyer mediators. It's the first time ever that the State Bar of California, or any state bar, as far as I'm aware, has ever given any type of professional recognition to people who aren't lawyers. The problem, though, is it's an exacerbation of the problem I just mentioned beforehand. Because if Joe Public sees that somebody who is not actually a lawyer is certified by the State Bar of California as somebody, as somebody who helps resolve litigated cases, that member of the public might reasonably assume that the neutral has got some type of training or competence in the law, because why else would they be certified by the State Bar? It's not as though the State Bar certifies plumbers or accountants. So there is a real risk of consumer confusion. Now, well, who are the consumers? As a practical matter, most purchasing decisions in the ADR world are made by lawyers, not by the ultimate parties. And surely lawyers will get this and will explain to their clients what it all means, what it doesn't mean. I'm not sure you can necessarily make that assumption, particularly in the early days. And you can't just assume that members of the bar will, as it were, be a filter advising their clients as to what this person's certification does and does not mean. Those are some of the problems, but there are others as well.
Do you have any thoughts on, the pros and cons of the certification process?
Well, I'm still trying to think of the pros. I can't think of any. But the cons.
Well,
first,
what did
let
the
me
legislature?
let me
Why did the legislature think they needed this?
trying to explain the conduct of the California legislature, as the saying goes, is above my pay grade. Let me say, first of all, that I'm very happy not only to be on this webinar with you, Howard, but also with John, because John wrote an absolutely spectacular article in the Daily Journal in December, John, of 2019, 24 that left SB 94, recording this on February 10th, the day after the Super Bowl. And John's article left SB 940 looking like the Kansas City Chiefs at the hands of the Philadelphia Eagles. He just took that statute apart limb by limb and left it crumpled on the ground. It's a spectacular article, and I commend it to you all. I think that there are some people, John, there are some areas in family law, divorce cases, where there are huge numbers of unrepresented parties who do have to hire mediators on their own as cost savings. Is this going to do these people, is this legislation going to do these people any good? I think not, for exactly the reasons you stated, because the certification is almost designed to confuse people into thinking it's a kind of licensure, or designed to confuse people into thinking that it's some kind of hallmark of quality. So it is more likely, I think, to mislead than to inform the consumers who need it most. As to the more sophisticated consumers of mediation services, the lawyers who serve as gatekeepers in so many of these cases, I don't think anybody's going to give a hoot. People have the mediators they like and don't like. They have their own ways of determining what mediation skill is and what it isn't, and whether mediators make the grade or not. And to think that lawyers, particularly once they figure out how vacuous this certification scheme is, I don't think they're going to give one rat's you know what about whether anybody has this certification. It is, as with most certification programs of this type, the way that I generally look at them, these are efforts by people whom the marketplace has not rewarded with business to deprive the people whom the marketplace has rewarded with business of the advantages that their skills and abilities and talents have earned them.
Very well.
Why? Go ahead, John.
Well, very well said. I mean, I agree with everything Jeff has just said. It does raise a question as to how did this come about and why now? And so for those who are not kind of familiar with the origins of the statute, it was all part of the fallout from the Tom Girardi scandal. Girardi being the highly successful in his heyday plaintiff's lawyer who went down in this terrible scandal to do with the mishandling of vast amounts of client settlement funds and recoveries. And the Girardi scandal didn't really implicate ADR in the normal sense of the word. We think about ADR, most people think primarily mediation and then also of arbitration. But the Girardi scandal really wasn't about mediation or arbitration gone wrong. But what happened in the Girardi scandal was that Girardi, who was, to put it mildly, very well connected in California legal circles, brought in to his kind of call a bunch of retired judges and justices from a very prominent ADR provider. But those justices and judges weren't really brought in to, provide ADR services in the conventional world. Yes, there was a bit of mediation if you can look at what happened at a granular level, but at a big picture level, these people were really more there as fiduciaries, more like kind of special masters, kind of just trying to kind of preside over the disbursement of settlement funds, the non-disbursement as it so often turned out. But they weren't really there as neutrals. But when the Girardi scandal broke and everyone was, outraged at what had happened, the focus was on the fact that these people came from this very prominent ADR company, and so the political world began to say something needs to be done. And the first fallout was the change to the rules of professional conduct, requiring lawyers to kind of report other lawyers engaging in unethical acts, kind of the whistleblower requirement. But then the next thing was this: well, we have to regulate this whole unregulated world of ADR neutrals. So that is how it all came about. Now, I think it's a fair question to ask. I mean, when it comes to, let's talk about just mediation. I mean, how widespread a problem is unethical mediation? I don't mean ineffective mediation. I mean, by definition, half of the mediators in the state of California are below average or below the median, if you could somehow reduce all mediation skills to a numerical score. Just like half of all dentists are below average and half of all plumbers are below average. I mean, that's because that goes with the territory that some are always going to be better than others. And guess what? 10% are in the 10% of mediators are in the bottom 10 percentile. But SB940 is a matter of kind of weeding out to the bottom 10 percentile in terms of competence. It's about trying to, as it were, recognize those who commit to being ethical. But the question is, how common is unethical mediation? I mean, Jeff, what's your view on that?
There is some unethical mediation going on out there, and we can discuss that. Let me elaborate a little bit on what you said, John. You mentioned that the people who caused the mischief here were from an ADR services company. I just want to make clear, as far as I know, it was not the company called ADR Services. And so I just want
That's a very good point. Yes.
I just want to make clear to our friends Lucy Barron, Joanna Barron, and all the people who work at the company called ADR Services that they're not the culprits here, and we don't intend to defame them in any way. The services that these neutrals were
using them in a generic sense.
I understand that. I just wanted to make it crystal clear. And also that the function that these problematic neutrals were performing was in what is called claims administration. And that happens in class action and mass tort situations where there's a common fund and the fund has to be distributed among hundreds or sometimes thousands of competing claimants. And of course, in many of those circumstances, the attorney's fees and costs are reimbursed out of those funds. And the allowance of costs to the plaintiff's counsel is oftentimes determined by those neutrals functioning as claims administrators. And that's where a lot of the corruption really sank in. In terms of what is ethical and unethical in mediation practice, there are some people out there doing things that I don't think is right. And we can get into that. Part of the reason that we have the problem is because of California's remarkable mediation confidentiality statute, which prohibits mediators from being sued for malpractice that occurs in the mediation. The tort system, the common law, is generally considered one effective means of regulating the conduct of people in civil society. It's an incentive for drivers to drive more safely and doctors to function more safely and for everybody to perform at higher levels of skill and competence. The mediation confidentiality statute that we have in California is one of a kind. Nobody else in the country has a statute like ours, insulating mediators from responsibility from misconduct in which they may engage. So to the extent that there's not effective regulation of the conduct of mediators, part of that is the legislature's own making. And the way to deal with it is not by piling on more regulation. The point of it is to go back to the legislation which caused at least part of the problem in the first place. In other states, such as Illinois, Ohio, the District of Columbia, New Jersey, I believe Washington State and elsewhere, they have the Uniform Mediation Act, which expressly allows for an exception to the privilege governing mediation communications for cases involving professional malpractice, which occurs in mediation. If the common law were allowed to function the way it should, then perhaps the call for some of this additional regulation would not be there. If you want to get into what is ethical and unethical mediation practice, we can do that. John, let me ask you though, if you know, who supported this legislation?
I'm actually not aware of any practicing neutrals who did. I mean, there may be some, but I've never met one. Now, some people might say, and maybe the members of the legislature might say, aha, this is just typical, because whenever you try to regulate a hitherto unregulated profession, the members of that profession immediately say this is terrible and it's going to actually do more harm than good, and that they bring up all these arguments why it shouldn't happen, which are really just a means of trying to keep middling eyes out of a little sinecure. I actually don't, though, believe it is the case. I think as objectively as one, objectively, I think there are just big problems with this legislation. So I don't know of anyone who really supported it. But moreover, if you take the view that basically the seed was indeed the Girardi scandal, I don't think that had SB940 already been in effect, it would have made any difference whatsoever. Because if you think about it, note all of these retired judges and justices who joined Tom Girardi, it would have been easy for them to get certified, because all they would have had to have done would have been to sign a bit of paper saying, yes, I'm willing to aspire to these standards. And, nobody's going to really say, no, I reject these standards. I think these are terrible things. I write my own standards and, it's these people would have been certified. Indeed, Tom Girardi himself, had he wished to dabble in ADR, could have got certified, because anyone could get certified. So the notion that basically this would have somehow prevented that really makes no sense. And what's more, even if hypothetically somebody had been certified who was kind of involved in it and would then be certified, well, they could still continue to ply their trade once certified, because certification, as we said earlier, is not a license to do anything. A better term would have been, by the way, registration. If you're going to have this thing at all, people should just register as neutrals who commit to certain standards, because certification implies some endorsement, some seal of approval. Registration implies simply that you've kind of signed up for something, and that would be a more accurate way. But unfortunately, I think the legislature wanted to talk up its statute and wanted to use the more kind of elevated term.
So, John, let me ask you another question. Let me please, Howard, follow up. John, do you think that this
is... absolutely.
Yeah.
Let me just interrupt for a second.
Sure.
It's usually the case in my podcast. I'm learning more than I dispose of knowledge, and listening to the two of you is great. So with that, I'm not going to interrupt for a while. So go right ahead.
So, John, do you think that this certification regime is just the creeping rat of licensure getting its nose under the tent of mediation?
I don't think so, actually. Interesting question. I don't think so. What I do think, though, is that potentially it has it has a danger that it might make it harder for independent practitioners to function. And that point, and I'll explain my point in a second, but that's predicated on the assumption that basically people do care about certification. You may well be right, Jeff, that in the end, nobody's going to care about this either way. It just becomes some kind of irrelevant piece of compliance paperwork. And you may be right on that. But if hypothetically somehow certification does become a big thing so that people do, make it a significant factor in their purchasing decisions as to whether somebody is certified or not certified, I think there is a problem with independent solo practitioners as opposed to those who practice under some umbrella. And let me explain why. One of the requirements to become certified, and again, this tracks the rules of court applying to court-sponsored mediations, is that you have to have a complaints procedure in place. So, one of the ethical rules, for example, is that you're not meant to, it's got to be a voluntary process and that you're not meant to kind of, bully people into settling or whatever if you're neutral. And so let's, you have a neutral who is maybe a tad aggressive in methods of getting people to sign up to settlement agreements. And that this crosses a bit of an ethical line in terms of how far they went in terms of bullying or controlling a party in what's meant to be a voluntary process. If in order to be certified, you have to have a system where somebody can file a complaint. Now, the state bar itself doesn't want to be, it doesn't want to set up its own complaints procedure. Rather, the providers have to have their own complaints procedures. Now, if you're on a panel of mediation, mediation panel, arbitration panel, one of those, they either do or can easily set up their own complaints procedure. And so that's not going to be a problem. But what happens if you're a solo practitioner and you're not part of a panel for either all of your work or for part of your work? What then? Because, if I am part of a panel, but if I was a neutral, purely kind of mediating cases under my own name, John Derrick, and somebody comes to me and says, hey, in that mediation last week, you were, broke such and such an ethical rule. It would be absurd for me to say, okay, I will refer that to my complaints procedure, and then the complaints procedure is just me contemplating what they say and then ruling on it and then applying whatever as I might deem to be appropriate. That would make no sense. And so the risk is, therefore, that solo practitioners will be outside of the orbit of certification because by virtue of being, they can't have complaints procedures in place. Now, Senator Umberg did a webinar with California Lawyers Association in December when this point was put to him. And his response was words to the effect of, well, certification, I guess, isn't going to be for everybody. And I found it a slightly troubling response because what does that meant to mean? That if you're a solo practitioner, you can't be certified as, properly adhering to or committed to ethical standards. That strikes me as fundamentally ridiculous and unfair, but yet that is the real risk. Now, there may be workarounds by having, for example, bar associations or, other professional ADR organizations setting up their own kind of procedures to which solos could somehow subscribe so that if I were a solo, I could say, well, I'm not going to adjudicate my complaints against me, but I will refer it to kind of XYZ Bar Association, which has got a complaints procedure for neutral in place. You know, that could be a workaround, but it too becomes problematic because, for example, what if a neutral is referred, refers a complaint to that organization? Who is going to be the final arbiter as to whether that organization gets it right? Because if that organization says, either we don't find that this guy did anything wrong, or we do find that they did something wrong, is certification going to ride on the faith of that organization? And if so, what is the role of the state bar? The state bar is simply going to rubber stamp what some, bar association at a county level, some other professional group says, be it a rubber stamp in favor of the neutral or against the neutral. And if they do just rubber stamp it, what is the point of state bar certification? What value is the state bar adding to the process? But if they don't rubber stamp it, it ultimately means that the state bar is going to have its own investigative system to validate or invalidate the complaints procedure outcomes that exist. But that means the state bar is going to have to start kind of having its own investigators, its own tribunals of some sort, which it, by all accounts, doesn't want to do, and which the statute doesn't make any provision for. So this whole area has just not really been thought through. Now, there is a working group that's been...
Excuse me, John,
Yes.
may let's turn the screw one notch tighter. Let's say that there's one of the big ADR companies, let's call it Brand X, and a mediator at Brand X who's a big rainmaker, some retired judge or high-profile retired lawyer who's bringing in $1 million a year worth of business. And that mediator is accused of misconduct and now is going to be reviewed by people whose incomes depend on that mediator bringing in $1 million worth of business and financing the operation of the whole overhead of Brand X, or contributing mightily to the supporting the very jobs of the people who were reviewing him. I think it was Upton Sinclair who said it's very difficult to persuade someone of the justice of a viewpoint when their livelihood depends on not believing it. And I think Upton Sinclair was right. And I think that applies big time. It's just another example of how this is not thought out. I listened to that webinar with Senator Umberg in December. I felt very bad for him. Because every time he was painted into a corner, and he was painted into corner after corner after corner in that webinar, when he obviously had nothing else to say, he would just say, well, maybe certification's not for you. It's just a voluntary procedure. And that response is just not good enough.
I don't understand.
I agree.
Yeah, I don't understand what the point of it is, honestly. I mean, do you need to ask me? Do you need to ask me whether or not I'm going to commit to be ethical? I mean, that seems like an absurd question to even ask anyone.
But it becomes more.
It's going to look like a Monty Python.
It becomes more.
And John Derrick's got the accent to implement the Monty Python routine.
Remind me
Indeed.
the Monty Python routine. Which one are you talking about?
Any of them.
Any of them would do.
John,
but it becomes even more.
Go ahead,
Monty.
John. I wanted to
I
ask.
was going to talk about the tiers, but did you want to? Yeah.
Well, we're going into the home stretch of our conversation here now. And I wanted to ask your view. You're so much more on top of this than I am. What can people do at this point? The legislation has been passed, and supposedly the mechanisms of government bureaucracies are going to be ginning up to implement regulations and all that. What can we do to prevent this from becoming any more absurd?
Sure. No, that's a great question. And the answer has to do with a working group the state bar has set up to try to work out how to implement this. Now, I have heard some people, during all the discussions about SB940, kind of slightly taking it out on the state bar, and saying this is just another opportunity for them to, get money from us, blah, blah, blah. I think it's a bit unfair. To the best of my knowledge, the state bar never lobbied to have this role. It was something that was handed down to it. And so to the extent that you or that one may feel kind of frustrated by this whole process, I don't think one should look at the state bar as kind of, the entity or against whom one should vent. What the state bar has done is to set up a working group of roughly 20 people drawn from different parts of the ADR world. And that working group, which is having its first meeting kind of pretty well this week or next week or something like that, is meant to be coming up by around about mid-year with recommendations as to how to implement the law. Because the whole, should we have certification or should we not have it? That ship has sailed. Indeed, it has docked at its destination. The fact is that unless the law is changed, we are going to have a certification scheme. And so the question now is, how do we set it up so as to do the least amount of harm? One of the issues that it's going to grapple with is this whole complaints thing. And they are going to be open to input. There's going to be both formal and informal means for people to submit their thoughts and ideas to the working group, and it's going to be a fairly transparent process. Besides the whole complaints thing, another aspect that the working group is going to have to grapple with is this point about peers, because the statute is actually worse even than we've already kind of discussed, because not only does it provide for certification, which has got which is kind of meaningless but also problematic for the reasons we've discussed, but it also provides for tiers of certification. So you can it doesn't talk about bronze, silver, gold, but that's kind of, the different levels of bling are what it implies. And the tiers are the statute says higher levels or tiers are awarded to firms, providers, or practitioners that demonstrate a higher level of commitment to accountability and consumer protection based on criteria developed by the state bar. So what does it mean? Because, you either are committed to these ethical standards or you're not. But say I'm really committed to them, kind of meaningless. So what are they going to do? I don't know. Maybe they're going to say, well, if you go through some 8-hour training course on ethics every year, you can go up a tier and get a shinier piece of bling than if you merely commit to the ethical standards without going through that training. But that could, just create this whole just compliance industry of busy work for people just to hit through kind of 8 hours of ethics webinars and merely for having attended them, be able to claim higher level of certification. The statute actually says, though, the levels or tiers do not reflect an assessment of the quality of a firm, practitioner, a provider. But that in itself is weird, because you'd think that somehow commitment to ethics is a quality thing. but the statute actually says, well, we want to give higher level of certification to people who are more committed to ethical standards. But by the way, that doesn't say anything about quality. I mean, it's bizarre in a way that they can say that on the one hand, it's got nothing to do with quality, but yet it's got to do with commitment. The State Bar Working Group is going to have to work its way through all of them. And an answer to your question, Jeff, I mean, all of us who've got views can submit our thoughts to the working group.
Sound advice.
Yeah.
I got to tell you, I don't think that there's a minimum level of ethics or a maximum level of ethics. You're either ethical or not in terms of as a practicing lawyer. I think people are just going to get confused. The tiers really, I mean, you looked at my notes, the tiers just kind of got me going, I don't understand that. I mean, there was a lot about this that I didn't understand. And listening to the two of you is great.
Well, it'll be interesting. There are things about mediation practice, common things about mediation practice, which are unethical to their very roots. For example, many mediators use so-called confidentiality agreements and include in there a prospective waiver of liability. The mediator shall have no liability for any act or omission in connection with the mediation. Not every mediator has that in a confidentiality agreement. Many do. If a lawyer tried to put a prospective waiver of liability into an engagement agreement with the lawyer's client, that is a flat-out violation of the California Rules of Professional Conduct and would surely make that lawyer subject to professional discipline by the state bar. That's just one example of common aspects of mediation practice that are at their root unethical. If a mediator who wants to get certified as subscribing to high standards of ethics nonetheless maintains confidentiality agreements that include prospective liability waivers, which are flat out violations of the rules of professional conduct for lawyers, then let me just tell you, we've got some big problems.
And I should remind everyone that lawyers are subject to the bar's ethical standards, where non-lawyers are not. Maybe that's what this is aimed at. Non-lawyers.
Well, I mean, I'm not sure that was the main driving force, because also the state bar, when it disciplines lawyers, would it discipline a lawyer for a breach of the ethical standards laid out in the rules of court relating to court mediations or private equivalents of those rules? The state bar, as I understand it, can only discipline lawyers for breaches of the rules of professional conduct. And the rules of professional conduct don't necessarily address everything that occurs
John,
or that could occur in a mediation.
John, I don't think that's so. I think the state bar regulates us as lawyers, we lawyers, in every stage of our lives. Because, for example, moral turpitude relates not only, and lawyers can be disbarred for the commission of felonies, which have nothing to do with the practice of law. So the state bar regulates lawyers in every aspect of their lives to a certain degree.
Right.
Yeah.
You have a point.
I agree with Jeff on that. Yeah.
But does anyone think that this law would be better if it didn't also cover non-lawyers? do you think if we're going to have this law or this certification scheme, it should include non-lawyers, as it indeed I think it will.
Well,
But
I think
in other words, if we're going to have this at all, do you think
there's pluses and minuses. I think that to have the state bar have mediators, some of whom are regulated by the state bar, some of whom are not regulated by the state bar, that creates open field for certain mediators, perhaps to engage in conduct that other mediators couldn't do and get away with it. On the other hand, the idea that the state bar all of a sudden is regulating unlicensed people who've never really agreed to be within the ambit of state bar regulation, well, that seems curious as well. So the conclusion that I draw, and perhaps it's just my confirmation bias at work, just another reason to scrap the whole thing. But I guess, as you say, the ship has not only sailed, it's landed.
Well, this is it. But, legislation can be changed, and maybe ultimately there will be some revisions to the legislation. But I'd be pleasantly surprised if it was simply going to be revoked or repealed. But what I do think, if indeed we are stuck with this, at least for the foreseeable future, I think one way of mitigating the harm is for the state bar to be restrained in how it implements it. And let me explain what I mean with this. There's always a risk that when you set up a new program and you have kind of people who are paid a salary to administer that new program, that they're going to talk it up and that they're going to kind of say this wonderful new scheme for, recognizing, excellence and mediation ethics, and that they're going to come up with, digital bling, kind of gold seals and silver seals, and people can put them on their websites like they do with kind of these super lawyers awards and things like that, dished up by the private sector. And it's one thing, if private companies dish out bling, we can all kind of make our own assessments as to what that bling is worth. But when the state bar, an agency under the under the guidance, under the rule, under the control of the California Supreme Court and a creature of statute, when the state bar gives out bling, it's got to be very, very careful as to what it's doing. But I think it shouldn't give out any bling. There should be no type of logo that people can put on their website. If you want to mention that you're certified, you should be limited to a piece of language which would make it exactly clear as to what this is. Kind of, I'm certified by the state bar, which means that we are committed to these standards. But this doesn't speak to anything more than that. It says nothing about my experience, blah, blah, blah. In other words, if you limit what people can do with their certification in terms of, as it were, using it in a potentially misleading way, you limit the damage. Whether the state bar will, as it were, have it in it to kind of be restrained in that way and to not kind of launch this whole thing with a fanfare and with all sorts of bling, that remains to be seen.
Gentlemen, we're just about at the end of this. I do have a question. If a listener was to walk away with one important thing, what would you say that is from this conversation? Why don't we start out with John?
Well, my recommendation is just do not attribute all that much significance to whether somebody is or is not certified.
And Jet?
Thank you, Howard. And John, it's a pleasure being here with you as well. To echo and amplify what John is saying, as mediators, and indeed as members of any profession or trade in our society, we should always be working to improve ourselves. We should always be working to refine and adhere to ever higher standards of ethics, just as we always should be working to refine and adhere to higher standards of skill as we practice. And we should do that regardless of any of these certification schemes or any other stuff that comes up from the state bar. Ultimately, I think that we will be rewarded or not in the marketplace and in our own hearts and souls by the quality of the practice that we achieve, and not by any gold star that somebody else sticks on it for us.
Well,
Well, I agree. And gentlemen, this was great. I was an audience member on this. Listening to the two of you in the conversation, I feel honored to be part of this with you. So I'd like to thank both of you. I will put information on how to contact each of you.
A real pleasure.
President.
Yeah, Howard, thank you so much for the invitation to appear here on your podcast and alongside very distinguished John Derrick.
well, thank you, Jeff.
Thank
A
you very
pleasure to
much,
meet you.
gentlemen.
I've read so much about you, Jeff, so it's an honor to have done this with you today.
Thank you.
You gentlemen have a great afternoon, and thank you very much. That's your wrap.
Okay, thanks.
Bye-bye.